Right, I've started. Okay, so the recording's happening now. So this is a guide for people who are mediators, and it's a practical guide. I don't anticipate that everybody's going to become an immigration expert at the end of this presentation. It's there to assist people in knowing how to signpost and knowing a little bit more, hopefully, than they do now. I'm going to just give you some of the aims of today's presentation. I'm not going to read them to you, because I'm sure everybody can read here. If there's anything that you think we've missed, or you want to have further information about, then just let me know, and I'll be happy to have a one-to-one with you, or we can possibly do it in the kind of group questions at the end when we have a general chat about the presentation, and maybe questions you have about clients you've met in the mediation room yourself. So I just explained a little bit about how I've come to where I am today. Okay, it's been a long journey, and I started off teaching English as a foreign language. So I did my CELTA, which is the Certificate of English Language Teaching for Adults, and I did it at Leeds, Beckett University. And then I decided that I would go to somewhere very exotic, and I went to teach in Bradford, where all my friends went off to Thailand and other places. And that kind of started my immigration journey, or my interest in immigration. As a teacher, you're in a very privileged position, sometimes very much like a mediator. You're seen as a bit of a guru. They expect you to know everything. And I used to always have a period of, like we did today, 15 minutes before, so we can sit down and deal with extracurricular things, such as, I don't know what this letter means. And one of the things that came up very regularly was letters from the Home Office. And this presented a number of issues for people who have English as a second language. And that started my interest. And I decided, alongside being a teacher, I would start to study my law exams. And I became accredited. And as you can see, the OISC stands for Office of the Immigration Services Commissioner. So that is the regulator for immigration advice. So a really important organization, a bit like, if you're a family mediator, a bit like the FMC, the Family Mediation Council, but with a bit more kind of, if I'm allowed to say that, a bit more clout. They come and audit you. They can prosecute you, especially if you're not a regulated immigration advisor and registered with them. So they're setting standards as well, very much like the FMC in that respect. Okay, and they're also public facing, so they help the public understand about where they can go and get help. I then went on to be a magistrate in the courts and moved on to family, and that kind of got me interested in the work that I'm in now as a mediator. And I went along, done my FMC, so accreditation, and then I recently become a PPC. Now, for anybody who doesn't know what PPC stands for, I kind of mixed it up when I initially became a mediator, and I thought, I don't understand why all these people are members of the parochial church council. But it actually stands for professional practice consultant. Okay, so they're mediators who can support other mediators in their development, and it's one of the regulatory kind of points that we have to have, is that every mediator who's accredited as a PPC. And then I've kind of developed my role since then into being a trainer, hopefully educating people about immigration and other subjects that I'm passionate about. Okay, so that's how we've got to where we are. Today, we're going to look at the common routes, okay, for immigration. We're not going to look at all of them. And these are the ones that we generally see in the mediation room. So they are fiancé, unmarried partners, and then obviously married and civil partners. So there's the general routes. There are obviously lots and lots of other possibilities for people entering the UK. We're going to just go through the common ones, but if people do have questions about more tricky kind of routes, then we, do ask the question, and we will. I'll do my best to answer them. I'm going to say here that I do not know all of the immigration rules. There are very many immigration rules, and I can tell you an interesting fact that we are celebrating. I don't know if celebrating is the right word, but maybe Priti Patel is. Celebrating 50 years of the immigration rules. They came out in 1971. So we've had 50 years of these rules. And they're what governs who we let in basically into the UK. Right. This is probably a presentation that isn't for people who appeal to Priti Patel's point of view on immigration. Okay. I am very much helping people access immigration. Now, I have someone who's raised their hand, and it's Family Mediation Wales.
I'm so sorry to bother you. I'm just aware that there's people waiting in the waiting room to come into the training.
Okay, thank you.
Thank you.
Super, thank you for letting me know. And it included Jack. That's why he's not been busy letting people in. Okay.
Been kicked off the meeting and he can't get back on.
There you go. Well, I have just let him back in and just let everybody in.
Hi.
So thank you very much. There we are, Jack. You've been deported from Zoom.
I know, quite
How
literally.
did it feel?
It felt like I was stuck in some sort of limbo purgatory with quite a bit of panic.
So that's fine. I think we've got everybody in. There's 70 with us, so that's good. So for people who have just arrived, you've not missed too much. We're just starting about that. We're going to be looking at the most common routes: the fiancé, unmarried partners, married partners, and civil partners. And we're going to just look at those for the start. Okay. So let's put things into context. Let's meet Juan. Okay. I'm still puzzled why Juan doesn't have his shirt on when he comes into my mediation room. But for many of us who do mediation, this has happened to me a few times. But I'll let you decide if you ask Juan to put his shirt back on. Okay. But Juan is from, let's say, from Mexico. Okay. And just for purposes that everybody wants to know, I'm sure you're asking the question, Juan is not my husband. Okay. My husband is obviously far better looking than him. Okay. So here he is. And he's from Mexico. So this is Juan's perfect immigration journey. Okay, so this is the ideal kind of scenario that Juan comes to the UK, the stage 1, and I'm just going to talk you through these stages. So stage 1 is is split into 2 parts. So you've got an either or. So we're going to start with the first possibility. So it's a fiancé visa. You hear people talk about this, and this applies to third country nationals, okay? And if you're a third country national, then you have to apply for entry clearance, okay? And these are specifically, you're coming to the UK because you want to join somebody who is a British national or who is settled in the UK, Okay, this is just this specific journey. Okay, so we're really clear. So let's say Juan is going to join myself. Okay, then this is the journey he would make. I'm a British national, and we have to pretend for the moment that I'm living in the UK, even though I'm not. Okay. So he has to, let's say if we are not married or civil partnered, and there's a choice there for people who are in a same-sex relationship. There's a visa that is an entry clearance visa as a fiance. It's a 6-month visa, and I commonly call it the try before you buy visa. Okay, so the try before you buy allows one to come here for 6 months, but in that 6 months, Juan and I should get married. Okay, so or civil partnered. If that doesn't happen within those 6 months, then one has to go back. Okay, back to his country, or let's just say leave the UK. Now, the very special thing is with the fiancé visa is that you are able to move into another visa category. If you came just as a visitor, you can't, generally speaking, stay in the UK and get married, and you generally have to leave the UK and apply for entry clearance. So Juan is applying from Mexico because we're going to get married. We've got this big plan. We've got a huge wedding down at the Travel Lodge booked, and we're all very excited. So the problem is that in Mexico, Juan and I can't get married because in some states in Mexico, same-sex marriage is not permitted. Okay, so we're kind of left with a scenario where we have to get married in the UK, or technically you could get married in another country that allows you to. But for Juan's journey, we're going to get married in the UK. So we get married and everything is very good. And then he has to apply for stage 2, okay, further leave to remain. However, if Juan and I decided to get married outside the UK, and because Ireland is a lovely place, we decided that we want to get married in Ireland, then technically he could just come on stage 1, the second part, because we're already married or civil partnered. Okay. So lots of people choose to get married outside of the UK because it reduces the cost of the immigration applications, and we'll look at that in a minute. So we get married, he applies for further leave to remain and gets 33 months. So he has to have 2 sets of that, okay? So you will always have 2 sets of 33 months, okay?
It's normal. No, it's normal.
So
We'll come back
can
on
somebody
again,
turn
all
their
right?
mic off, please, if possible? Okay. So we have to keep making all
Yeah, it
these
just means it's got
applications.
its temperature down. It'll come back on soon. It'll only go off for a little work bit.
Okay. Somebody just, whilst they're talking to Dad, it's very nice. I'm pleased that we have strong family connections. I'd just be appreciative if whoever's chatting has just turned the mic off. Okay. So these are the number of applications, and currently they're all done online. And you only need to go to give your biometrics. Okay, so there's no longer kind of turning up at the Home Office. The Home Office has actually privatized a great deal of this, and they have a partner called Sopra Steria, who actually will facilitate you making the application, i.e. fingerprinting, you taking your photo and things like that. So you can see that Juan, on his perfect immigration journey, has to go through initially coming to the UK, 2 sets of visas, applying for indefinite leave to remain, which has a million different names: permanent residency, settlement, and these are the different types of visa application that you'll hear clients talk about. And of course, stage 4 is the arrival in utopia, the British passport. Okay. So we're going to look now at costs. So I'm going to ask, just anybody can answer this one. Do you think this is a cheap experience for Juan to get to stage 4? Anybody there? Anybody?
No.
No, thank you, Jack. It isn't a cheap experience, is it? So, and this is something to think about, okay? So I'm going to let you see now the associated costs. So this is if Juan doesn't kind of go crazy and do all the fast tracks. This is the basic service. And at the end of the day, he will spend just over £10,000. Now, I don't know, you may be very rich mediators, but for me, that is a huge amount of money to spend. And we could add at least another maybe 2,000 plus if we wanted to fast track everything. So we could be looking up at 12, 13,000 at the end of it. And I need to tell you, that excludes lawyers' fees. So if they needed a lawyer, then there would be additional costs, and they vary the costs. Okay. Now, do you think the immigration application process is going to be a simple one where you can manage it without a lawyer? Any voices out there? What do you think?
No.
No,
I suppose you could, but it would be extremely difficult.
It would be extremely difficult. I think if you have a legal background, then there's a good chance that you may be able to make it through. But there's lots of little things that may catch you on the way, such as if you present your bank statements, they have to be within 28 days of your application. The date of the application is actually when you submit, not when you turn up for your appointment at Sopra Steria to hand in your documents. They also have to have a stamp from the bank on them to say that they're valid, bank statements. So really, it's important to just realize what a difficult journey this is. And somebody's asked a very good question. IHS, it stands for Immigration Health Surcharge. Now, if I'm allowed to be a little bit lefty, you can see that immigrants pay a huge amount of immigration health surcharge. This has been recently brought in, and every year has increased considerably, starting off at £250, and now we're getting to fees that are generally in excess of the actual visa application. The immigration health surcharge was brought in for healthcare costs. And I have a real issue with this. So a lot of my clients that I deal with are working, like you and me. They're paying their national insurance and they're paying all their taxes. But this is a special tax purely for immigrants. And I would argue, as would many people, that they are doubly paying for their access to healthcare. Some of you say, well, it'll pay for their spouses and their children. Their spouses and children will pay a separate immigration health surcharge as well. Okay, so a crazy amount of money. And Juan really does have to have a lot of money there. Michael asked a question. As a fiance, you cannot work until you've got married and you apply for further leave to remain. Okay, so that's absolutely right. So the fiance is the first stage. you can start working immediately when you have entry clearance as a spouse from outside the UK. So if you were married and came in, you could immediately start working, as long as you can start working technically straight away because you have the right to work. Whether anybody will take you on, it's a different matter, because trying to get a national insurance number is incredibly time consuming and very difficult. But yes, if you come as a fiance, you have to wait until you actually can move into the further leave to remain category. Okay. So Juan has come to mediation because obviously he's having a bit of trouble. His relationship has broken down. And I think one of the things that we will notice on a lot of people's passports, it will say no recourse to public funds. Okay. And people think, oh, that's it. They can't access legal aid. Now, we wrote to the legal aid and said, okay, can we just ask for clarification on this? They can actually access legal aid, okay, for family mediation if you have a legal aid contract. So whilst one might be having a very difficult time, if he's on, let's say, such low income, he could potentially get legal aid. Okay. So it's, he's come to you or Mayam, he's sitting there. There may be lots of questions. And I think as a mediator, it's thinking back maybe to where has Juan got to on his immigration journey. Now, if he has got to the stage of indefinite leave to remain, it's happy days. Well, happy as they can be, but happy as in an immigration sense that he can't be removed. When you have indefinite leave to remain, settlement or permanent residency, these are the terms that are bandied around, it basically means that you can relax, you're free of immigration control. And people get very excited about that. And most people I've seen people spend their lifetime just sat on that. They don't progress to British nationality. They just remain with that status. And they feel that that is okay. And that's no problem at all. So if one has got indefinite leave to remain, he may have British nationality, depending where he is on his journey. Then immigration won't pose much of a concern in the mediation room. So he's there having his Mayam, and for people who aren't mediators, a Mayam is a mediation, information and assessment meeting. And we find out that Juan has been kicked out of the family home. He's financially destitute because the joint bank account has been emptied. He hasn't seen his children. And we have a really very common situation here is that his spouse has said, I'm writing to the Home Office to tell them that our relationship has finished. And this you will see many, many, many times. And we will have a chat about this later. I have some letters for you to look at. Juan also has language skills. And that can pose a problem because it's accessibility to all of these things. So obviously you will do a fantastic screening in your mind and you'll be able to signpost. But Juan is, I would say, in a pretty desperate situation where he is really on the edge of society and probably needs a lot of intervention to be able to, for you to assist him. So we talk about signposting and contacting client B, the respondent party, and what we need to do next. So all these kind of things, it's really important that in your practice, you, we have got pages in community languages now, so that we can give people information about the mediation process if they don't speak English as a first language. And on our website, we have a signposting page explaining about housing, immigration, family law, and you know, and we talk to people within those within the MIAM about where they can seek help, or if we need to make a referral. So in many of these situations, they don't have the ability, or they might not have access to the internet, or not being able to have that conversation. And if they give permission, we make the referral for them. So what does one do next? Well, I'm going to share in chat now a letter, okay? And we have to pretend that one receives this, okay? So this is where the magic happens. So the magic will happen, and I will get there. Okay. So you should have, I've stopped sharing my window now, and I'm just going to bring up a letter that one receives. One in the meeting. If I can't, I'm going to read the letter to you. It looked so easy on the training course when I did my Zoom training. So I'm going to actually just read the letter to you. And one gets this, and he's a little bit concerned. Actually, I have a great thought here. I can actually share it if I've opened it on this way. Okay. Perfect. Now we should be able to see the immigration letter. Can we all see that?
Yes.
Can we?
Yes.
Yes, great. Okay.
Yes, yes.
So this comes through. I've redacted it. It's a letter a little bit old from 2018, but nothing's really changed about the process. And Juan gets this letter. Okay. So this is the first letter he gets. Well, there's lots of vocabulary in there that would be really challenging for someone. And it's a little bit scary receiving things like that. The second letter gets even scarier. Okay. And this is part 2. And it's just opening. So we're going to see this letter now. So he receives this. Your leave to remain has been curtailed, so it now expires on the 23rd of June 2018. You now have until this date to either make arrangements to leave the United Kingdom or submit an application for further leave to remain. That's as much help as the Home Office gives you. Now, Juan receives this. Do you think he's scared? I think Juan is petrified. So actually, he may be very scared of telling you about his immigration status, because he may see you aligned with authority. So I think in mediation, in the MIAM, we need to stress that we aren't the immigration police, that it is a confidential process, and that one can speak to us about his immigration status if he wants to. So this is a very difficult situation. And he may bring the letter to you and ask, what does this mean? This letter that you see here is as a direct result of this gentleman's partner, ex-partner, writing to the Home Office saying, we're no longer together. He's moved out of the family home, and that is the end of the relationship. The Home Office miraculously respond to these letters quite quickly. Any other letter they won't respond to, but here you have it. They are quite fast at this. Okay, I'm going to share the next letter that he gets, or the attachment that he receives to that letter. Okay. So this is more details about his case. And this gentleman came from Pakistan. I'll just scroll down a bit. I won't read everything, I won't read it out to you, but the language here has a great deal of technical kind of aspect to it. And I think anybody who's just a normal person would be challenged by this type of letter. But there's a very important line here, which no regular client would pick up, was the section 55, which we'll talk about. And you can see that consideration has also been given to section 55 of the Borders, Citizenship, Immigration Act 2009. And they've said that they've considered the impact it would have on children. This is a very standard paragraph that they put in the letters. In this case, they hadn't. Okay. So this is a very important part of the immigration rules that need to be considered. Okay. I'll just scroll down a bit. Well, then we decide to just threaten Juan with a fine if he doesn't send his BRP card in, just to make him feel a bit better. And the letter goes on. Some nice bold capitals there underlined. No right of appeal, no administrative review. And goes on about liability of removal. They spend more time telling you more about how they're going to remove you, and the £20,000 fines on people if you're working for a company that employs an illegal migrant, and all the horrible things that you'll be charged for healthcare now. Your bank accounts may be frozen, and you can't drive. And it tells you how long they're going to, if you overstay, how long you'll be banned from going to the UK. And then, very helpfully, they'll tell you about their voluntary return departure service, which from my experiences, when clients have said, can you assist me? I can never get through. So this is the letter that Juan receives. And if you think Juan's paid all this money, he's been a good citizen, and I would say Juan has done nothing wrong except that his relationship has broken down. I don't know about you, but the letters that you've just seen certainly would make me feel like a criminal. I don't know if people agree with that statement, but it's not said in a way that just it mainly focuses on breaking the law and what would happen if you didn't leave.
That's right, I would agree with you, especially having trained as well in community interpreting. A letter like this just scares the hell out of people, because obviously the language is an issue. There's terminologies there that are not understood by the majority who are foreigners, and therefore it's just too much. It's just too much.
Thank you, and I think that's obviously you have first-hand experience of dealing with people like Juan, who really just don't know where to turn, don't know where to go, don't know who to ask for help. And I think this is the role of the mediators, to really know how to signpost effectively. So we're going to go back to the slides that I have. Okay. And we're going to look at the Human Rights Act. So I'm going to share this. So this is probably one of the most important pieces of law. And we still sign up to the Human Rights Act. Okay, just about. I think the government were wanting to tweak it and have their own version, but at this point we're still all signed up for it. So really importantly to note, this is the centre of the argument for Juan to stay in the UK. Now, as you can probably, as you're reading this, the definition of family life in Juan's case would be having access to his children. Okay. Now, he can only, there's something called exercising your Article 8 rights. Now, this is all a bit technical, so you have to bear with me. If you have any questions, just ask as we go along. So exercising your Article 8 rights. So Juan tells you in his Mayam, he is not seeing his children because his ex-partner has stopped all access to the children. This means that Juan is not exercising his Article 8 rights. And the Home Office say, oh, because he's not exercising his Article 8 rights, we're going to send Juan home. Now, in mediation, there is a very big power imbalance. And this is what we all have to note. Because number one, Juan's partner can say, well, you know what? I'm just going to report you to the Home Office. One threat that can be out there for you to be aware of. I know that you can only stay in the UK if you have access to your children. So actually, I'm going to stop access. And therefore, there's no Article 8 argument to be made because you aren't seeing your kid. Now, this business of seeing the child is incredibly important, and it can be used and abused, the Article 8 argument. Okay. There are, you will see people come to mediation who will very interestingly, if you think back to those first slides, they get a visa for 33 months, yeah? At month 30, they go, I want to see the kids. And this sometimes happens, okay? So, and that might be, you know, we're not there to make judgments as mediators, but just be aware that it's Article 8 can be used in a way for immigration purposes. Okay. Now, Juan is a nice man, and he genuinely wants to see his kids, but he's really left in a very difficult situation. Now, the important bit here is there should be no interference by a public authority with the exercise of this right, except in accordance with the laws. So, very important that the authorities don't try and fiddle with the family life, but you know, as mediators, we've got to say, well, what happens here? So it's worthwhile, obviously, if everything else is okay, for one's ex-partner to be invited to mediation, but always be aware of the power imbalance and the situation that one is facing and where he is on his journey. If he's got the settlement, indefinite leave to remain, permanent residency, one is fine. You don't have to be worried about that. It's those stages before where one is terribly at risk. Now, is the amazing Angela Moores here? I hope she came today. If she didn't, is Angela
Sadly,
there?
I don't think Angela's joined, Stuart, unfortunately.
Okay. No, that's fine. Thank you, Jack. So Angela is a family solicitor, and we've worked together on cases. So it's a bit of toing and throwing, really, as the immigration advisor. And we had mediators, immigration advisor, family lawyer, we have the courts, everybody, and there's so much paperwork going around that it is a real challenge for even, you know, one has to trust the professionals that he's working with. So one has to change his immigration path, as you saw from his letter. So at this point, you won't believe it, but one has to find another £1,033 to make his immigration application for, hopefully, FLR FP. Okay. And that's the immigration he would have to make if he was having access to his child. Now, as we know as mediators, there's two types of access. There's direct access to a child and indirect. If you're having indirect access to a child, or if one is having indirect access, it really isn't going to help his immigration application, because their argument is that one can have his immigration, so one can have his indirect contact from Mexico, is the argument there. So what one is needing to have in this instance is direct access with his children. And if he is making an application to the Home Office, he has to show evidence of this. Now, evidence can be done in a multitude of ways, but the safest piece of evidence, as you might have all guessed, is one having a court order stating very clearly direct contact for one. You may be able to have a parenting plan, but the very best that, you know, that would be encouraged is for a court order to show that one is having contact. It also protects one and also balances the power imbalance in the scenario as well. What one has to be very much aware of is that he gets permission of the court to use that document within the immigration application. So we have to be, one has to be very mindful of the time, because remember, his clock is ticking because he's been told he has to make an application or leave. So what is generally probably one's, if he had a good lawyer, would be to submit an application to the family court straight away, get the amount certificate, make that application, because do you remember that letter talking about section 55? Yeah, we need, what happens is we've got layers of priority. The family court take priority over Home Office proceedings. Okay, so the family courts are far more important because of this section 55, because the state can't interfere with Article 8, with the rights of, especially of a child, because we're looking at it from, I always look at it from the child's perspective, that the child can't see when if he's in Mexico. So it's always good to lodge the application at the family court, because let's be honest, when we talked about fast tracking applications with the Home Office, they are, if you don't fast track, they generally trundle along maybe for up to about 6 months. Okay. Okay. Just a reminder to people just to put their mics on mute if possible. Okay.
Just my mediation. I haven't joined them very late.
Oh, well, we're having a very nice dialogue with somebody. If they could just mute, that would be great.
I think it's annoying.
Okay, so.
You good? Did you sleep well? How was your dream?
Yeah, access and language. Yeah, it's very right what Janet's brought up, is that access is a bit of an old term for people, and it would be child arrangements, obviously would be the better. So thanks, Janet, for that. I'm using old terminology and I need to be a bit updated. But it may be the language that other people use, and lots of different words are banded around for child arrangements as they are for permanent residency. So thank you, Janet, for that. I'm just seeing the question. So Michael says, is Juan at risk until he gets indefinite leave to remain? He absolutely is. Okay, so thank you for those questions. So Juan has to find this 1,333 very quickly. And if you think he might be on the street, he might be in a real predicament. If that doesn't happen, then he may become illegal, and that is that's a completely horrific kind of situation where his status in the UK is potentially questioned, and he could end up in a detention centre, unfortunately, if he's caught. So your kind of to-do list is to think about these things. And I think as a mediator, the interpreters thing is the one that comes out that makes me think about this most. Because signposts, using interpreters are expensive. You know, especially if they're a client that for whatever reason doesn't qualify for legal aid, it's a real problem. Okay, because we found out, I think Jack was doing a MIAM, and they said, "Oh, don't worry, we don't need an interpreter. Uncle Fred will do the interpreting." Unfortunately, Uncle Fred spoke less English than the client and was more a hindrance than a help. So I often will say, we do recommend, especially if they're legally aided, there's no issue, we always use a professional interpreter. Kind of link up with a organisation that provides and works within the legal aid kind of low payment bracket. But if sometimes with private clinics, as private clients, they will say, "Oh no, I want to use somebody." But for mediation itself, we always insist because of conflicts of interest, etc. It's always best practice. Okay. Michael asked another great question. So if there's no child, Juan is stuffed. Yes, unfortunately, if Juan doesn't have a child, he's not able to exercise his Article 8 rights, because there could be other arguments, but generally speaking, he would be in a really difficult position and would have to return back to Mexico. So children are the key here. If there are children, then it's really, they are sent to the kind of immigration application for the application that we saw, FLR, that's F for further, L for leave, R to remain, further leave to remain, FP, family permit. Okay, that's if he has a child. Juan may be very talented, okay, and his employer may be able to get him a work permit, okay, a tier 2 work permit under the points-based system. But that would be if Juan was doing a specifically skilled job or a job that's listed on the shortage occupation list. So it's always worthwhile looking at, getting immigration advice, because whilst Michael, your one might not have any children, there might be other routes. So, for example, I've done cases where I specialize in LGBT and same-sex relationships and visas. They maybe one didn't come from Mexico, he came from Ghana, he came from Pakistan. I have had cases where a young lad's been into a forced marriage, come to the UK, and the relationship's fallen apart because he's identified as he identifies as being gay. Causes lots of issues. He can't return to Pakistan because he would face persecution because of his sexuality, and then he could make a valid asylum application. But these are really complicated kind of scenarios, and it is very much worthwhile getting some advice from somebody who's qualified. What if the children are not Juan's, but he may have PR? Yeah, that's fine. I think we would be looking at an argument about what would the impact of, and I've done cases like this, of even though he may not be the father but has PR, the impact on the children and the life and the role that he's played in those children's lives. So really important to kind of get professional advice if, and you don't have to pay for it. Okay, so I've put here, you know, these are some of the organizations that are offering advice. Some of them are, you know, free, some of them are chargeable, and the OISC is the first kind of point of call. Okay, so that's, you know, that everybody on that register are specialists in immigration, and there are organizations that don't pay as well. Okay, you don't have to pay, it's a free service. CAB is also good, and Member of Parliament, you can go to. Some members of Parliament, I used to work in an office, and our Member of Parliament was fabulous. Okay, really proactive. They're very good to get updates if the Home Office aren't responding to maybe an application that's been in the system for a while. And that's just that they can be a really good source of just support as well. A lot of universities, I think there's quite a few students from Sussex University. If you're there today, you can shout out.
Hello everyone.
There you go. Thank you, Somto. At least one university student turned up today. There's Sussex University, who I work with. They have Clock, and they're really amazing. And they have immigration help. But lots of universities nowadays do have legal clinics where they can support people. Personal support unit maybe is more linked to family, but they may have people to signpost. And many firms, solicitors firms and immigration firms offer 20 minutes free consultation, where they say, okay, you know, you've got to this point, this is where you should go next. Okay, Michael has asked another question. What is your family status with a family permit? So Juan, I'm going to say, is here as a spouse. He can work, and it lasts. The visas always have a start and finish date. Generally speaking, for the 2 sets of visas that I would have would be 33 months. Okay. So we're going to play a game now. Okay. Because I thought it's, you've all been sitting there, you're all probably thinking about lunch and dozing off somewhat. And the game is called, Will He Stay or Will He Go Now? Okay. Sorry, I had to put a pun in there. It's just to keep you entertained. So we've got a few scenarios, and I want you, there's just 2 quick ones. And I'm going to just talk you through. Okay. So we're going to talk, the first role play. This would be if we put you into breakout rooms and everything, but nobody likes a breakout room, and most people kind of run away at that point. So Juan has a brother called, I'm trying to think of one of my relatives' names. Pablo. Okay. And he's a Mexican national. And he's been living in the UK for 4 months. And he came to the UK on what I call the try before you buy British, a fiancé visa. And things have not gone well. He has suffered acute domestic violence, and he is really not in a good place. He has no recourse to public funds because he's on a fiancé visa, and he is really challenged. Will he stay or will he go? This is the big question. Does he have any right to stay in the UK? I think people are shaking their heads. Amy is absolutely right. And Michael has said go. He is a goer, I'm afraid. He has to go back, even though he's been a victim of domestic violence. If he'd actually managed to get into the marriage part and the further leave to remain, Pablo could have stayed under the Domestic Violence Act, okay? But unfortunately, it was during that temporary visa period where he doesn't have any access, okay? So poor Pablo, he's actually having to go, Right, so we've got you another one here. Ali is from Morocco. He came to the UK and claimed asylum, but his claim was refused and he was asked to leave by the Home Office. Ali didn't want to leave, so he went underground. Ali is only 20 and he loves clubbing. On a night out in Leeds, he meets Amy, a British national, and they have a single night of passion. 9 months later, Amy gives birth. Amy contacts Ali and tells him he is the father. Ali comes to mediation as he wants to have contact with the baby. What happens next? Will he stay or will he go now?
We'll stay.
He's going to stay. That's right. So he has the right because of the Article 8, because he wants to see his kid. He'll have to make endless applications, an FLR FP application. He'll have to put stuff through the courts potentially if he wants a court order. Parenting plan may work. You can always try that. So yes, we've got two very contrasting people, and it's is he on the birth certificate? Well, let's hope that Ali gets himself on the birth certificate, because he has a very good mediator who signposts him. Oh, very good here, Zambrano carers. I would have to look at the Zambrano cases, that case law in immigration. Zambrano kind of falls outside the immigration rules, but it's to do with case law. When we talk about case law, there's loads of case law like Surinder Singh applications, and these are where there's been very interesting cases in the immigration courts where they've set a precedent. Okay, I will look into that because I couldn't say exactly straight away, Helen, about Zambrano. I'd have to look it up. Okay, but I will do and come back to you. So we've played Will He Stay or Will He Go? It's a bit of life seems very unfair, especially within the immigration system. Okay, so that's something to really just think about. It's not as, whilst you may think they should be able to stay, the reality may be very, very different. So these are my contact details, and I've wibbled on for an hour. Okay, so the idea is in about probably about a week or so, we'll be sending out an email to you. I'm happy to do chat with you as a mediator, or chat with your clients for 20 minutes to talk about the immigration route, or if there's any complexities, we can certainly talk through them. I've set up a company called Pride Immigration. We do all types of immigration. Okay. This is, we have it cut, it's kind of separated into two. Pride Immigration, you'll see that logo, and then we have another logo. This is for specializing on LGBT plus matters. Okay. And then we have a Pride website, which is, we're very conscious about the issues that the LGBT community face and the prejudices. So we keep the two separate. So we have the same company, but we have two separate websites because they concern very different kind of questions and issues. Okay. So you can always contact me on the two numbers that you can see there. If you can't get through, send a text on my mobile and we'll always come back to you. I'm happy to sit with you and for 20 minutes, talk through a case, and maybe, or talk to your client as well, just to give them, tell them what the next step is going to be for them. Okay. Right. So you will receive this slide by email. And you'll also give, our website goes live next week as well. So we'll be able to let you go, and you can give that to people if they want to signpost themselves and do a referral, self-referral. Right, questions here. Asylum questions, great, okay. If someone is claiming asylum, could they be eligible for legal aid? If you are claiming asylum, yes, you can claim legal aid. You can claim legal aid for family mediation as well. Okay, so no issues there. Domestic violence, yeah, helping. It's a They used to, for LGBT, I think there's a very specific organisation called Broken Rainbow. You'd have to just check with that. Domestic violence, yeah, there needs to be evidence in these cases. And with the evidence, I normally say to clients, please go and see your doctor, get a doctor's report. If there's physical marks, please, make sure that the doctor records these as well. The Home Office are particularly difficult when it comes to evidencing things. So independent referrals are really important to register it with the police, register with the GP, register with if maybe Women's Aid or the male equivalent. Yeah, and I can see here that Jack says GP reports will be free for domestic violence. Okay, so it's really important that they get this evidence before making an application to the domestic violence route, because they can't just say, oh, I'm a victim. They won't. The Home Office are very difficult people to persuade. So this is your moment. It's a free-for-all. You may want to just drift off for lunch and have an early lunch, or you may just want to ask some questions here, and I'll do my best to answer them. Hopefully that has given you a kind of a whistle-stop tour. What I do need to stress is, whilst you can provide information, and as mediators know you do this already, you're not allowed to provide legal advice. The OISC are pretty harsh on people who provide immigration advice if they're not registered. So, work out where they are, but don't give any advice. Just signpost them and build relationships with organisations that can help. I'm just going to talk on a few things that come up very often with clients that I deal with. And they say, my visa is finishing on Monday, and they put in an application on Friday. When Monday comes and they still haven't got a decision, obviously, do they become an illegal immigrant? Okay, and this comes up, and employers will say, I'm not employing you because you don't have a valid visa. If you put an application in before your current visa expires, there is something called, this is important, Section 3C leave. So for Juan, it's very important that he puts in his application before his curtailment of his visa happens. So he should put his application, the best application he can make, let's be honest. He may be really struggling with time. He should just submit something. So if you can't afford immigration advice, try and find a charity, but if you can't, then just put something in. It stops the clock. Section 3C leave would mean that he would be able to continue working, and that he'd be able to continue his life as he did before until an immigration decision has been made. Okay, so that's a really important thing to tell clients, that, tell them to look at Section 3C leave if they've already made an application. So they may not have any documents. They say, I made an application 4 months ago, I've not heard anything. And a lot of employers will struggle, a lot of people, one would struggle, to be honest, to get a job anywhere, because people are incredibly scared of the £20,000 fine for employing an illegal migrant. There is the employer helpline service for checking immigrants. And I always encourage people to tell their employer, potential employer, that there is that option. I'm going to read some, just before that, I think one of the worst companies I've ever seen with employees, I'm going to name and shame them, was Harrods. That I've had loads of issues with clients who have worked in Harrods, and they've threatened to not renew their contracts. So, after we had arguments, not arguments, but discussions that had an employment law aspect to them, they changed their position. Let's have a look at the questions. So if there's no child and you are stage 2 and you're applying for DV, yeah, Michael, you can stay if there's DV and no children. So that's why a lot of cases, there is again, like we're talking about abuse of, coming to see your kids, there's abuse of DV as well. There's quite a widespread abuse of that. So it's always about being very mindful and, talking to people and screening it properly. Has he time to make a court application for child contact arrangements? He should just bung that in straight away, in my opinion. But he should really probably get legal advice. But I would simultaneously put the 2 applications in, because the court application will just trundle along. And as long as we've got, as we remember, as long as we've got a family court application in section 55 prevails, which means that takes precedence over the Home Office removal. You might have to remind them a million times and tell them that you have, a case in the family courts that hasn't been finished, but that should stop the clock for the Home Office. Marianne, is Marianne there? Where are you, Marianne? Ah, brilliant. Marianne 2, are you Marianne 2? Oh, you are. You're telling me that there is another Marianne Roberts out there. Marianne, we can't hear you. I just trying to unmute you. Oh, there you go.
Sorry, I want to just refer to a situation I experienced recently in a mime. A Nigerian woman was very concerned because the father of her child had shown no interest for many years in that child, and now was seeking to establish a relationship. She claimed primarily to secure his visa status, and it had been a very problematic relationship. There had been allegations of domestic abuse, so she was of the view that he was wanting to see the child only and primarily to secure his visa status. And I just wonder if you could comment on that sort of situation.
Yeah, absolutely. So the FLR FP visa is very special. If it wasn't Juan, and let's say it was Ali, who we saw in our Will he stay or will he go now scenario, Ali was totally illegal, but the Home Office accepts that the Article 8 right to a family life with a child is more important, and that allows anybody to make an application for a visa under FLR FP. And yeah, I think a lot of people, you see that a lot in mediation. I think, Marianne, it's not something uncommon that, somebody hasn't, like I said, somebody hasn't seen their child for, for months and months, maybe years. Then all of a sudden they become aware of their immigration status. So I think, you have to do your job. We can't make judgments as mediators, and we follow the process. We have Gillian, who's just come up, or Gillian, I hope, whichever way you pronounce it. A mediator who works in the family courts as a mediator twice once told me that when there's a child application for child arrangement in courts, I'm not sure if she's meant magistrate or judge, realize this, they will not hear the case until the immigration is resolved. That is not the case that I've experienced. I don't think that's right, because it wouldn't be the right way around. All the cases that I've dealt with, because the priority of the child is there. So we have it the other way around. Magistrate wouldn't ever deal with a international case where there's issues. I've been asked by the courts to give information about the immigration status of an individual. And remember, it can't really be resolved, can it, until the family aspect of it is, because the Home Office is making a decision on the outcome of the family courts. So it has to be family first, then the immigration. But I will certainly get, it's the section 55 that we saw in that letter that you're challenging it on, that there's still on business that's not been dealt with. Okay. Right, anybody else with questions?
Amy has her hand up.
Oh, Amy, thank you.
Just to say, I also happen to be a family magistrate, and we deal with cases like that quite frequently. And of course, the family magistrates or judges, the court, are only concerned about the child's welfare. And if we feel that the child would benefit of that parent being present and everything, then an order would be made. At the moment, there is an extreme delay in the family courts. And when I say extreme, I mean extreme. It just for a second hearing will not happen before 6 months or something like that. And the court would need to be convinced that it's in the child's interest and that the person is not using the process merely, in inverted commas, to change their immigration status.
Amy, that's a fantastic response. Yeah, you're obviously allowed to do more exciting things than in the court I was in Leeds. All the juicy international stuff went to the district judges, and they wouldn't allow us to do any of it. But
we haven't got enough district judges.
Oh, right.
So we are doing all sorts of things that used to be reserved for district judges. They are just so desperate. So, yeah.
So you're getting more exciting stuff.
Yes, we are.
Okay, brilliant. Okay, any other questions? Okay. Like I said, there's has somebody else got a hand up? Oh, there's two people. I've got Peter's raised his hand. We'll just deal with Peter first. Okay.
Oh, yeah, it was just whether there's any tips on if someone is being abused more subtly, perhaps I can describe it, than violence. What about reports then? What about evidence to satisfy the Home Office then?
Yeah, it's a really good question about that kind of where does it. Somebody asked Jack and I that question about a week ago about what defines domestic abuse. I think if in doubt, you make the referral, you go through the process, and the Home Office will make a decision. Evidencing it is, again, the tricky part, isn't it? Because as we know, domestic abuse can be so subtle. But then we often, sorry, Jack.
Sorry, Stuart. No, I was just a good place, sort of evidence where it's more that coercive control, emotional abuse side of things, where there aren't visible bruises, rather than using your GP, who, if you've got a supportive GP, then yes, but using local domestic abuse charities with the specialist caseworkers there, as I have seen evidence letters written by them in the past, which have been used for exemptions at court. So I don't know, I don't do immigration, but I would hope that that sort of evidence would work there as well. So referrals to domestic abuse charities, specialist caseworkers, good place.
Jack, you previously worked in a charity, didn't you?
I did.
Dealt with this.
Yes.
Yeah.
Yes.
Somebody also was just wanting to ask a question. Anybody?
Yes. Hi, Stuart.
Hi there.
Thanks for a great session. Just a quick question around Brexit, really, and whether or not that has impacted the points of appeal for applications made under Section 8.
Basically, Brexit is a nightmare for all lawyers. There's lots of interim measures with regards to people who have come before certain dates and then people who have arrived after. Basically, nowadays, if you arrive, a good example, if somebody arrives, let's say from Spain in the UK, they are now treated as a third country national, which is the immigration rules will apply, rather than the European immigration rules. There used to be two sets, and it's just working out, very complicated, to be honest, working out where they fit in their journey and within the immigration rules as well. So it's a case-by-case situation. Obviously, if it's going, children will always come first. And I think that's something that we always need to stress. So not a brilliant and detailed answer, but it's a case-by-case basis I would look at.
And I guess thinking about the delays in the courts and COVID, we won't have that case law necessarily yet, will we?
Yeah, and the problem with poor Juan, let's just say, is that, let's be honest, this could drag out for months and months and months. That's why it's so important for Juan to make an application to the courts. And it is a question of just dragging it out as long as you can, because remember, if he makes the application to the Home Office, before his visa runs out, he continues with the leave he had previously. So it's telling the Home Office, no, we're still going through the family courts. And when that decision has been made, then giving that evidence to the Home Office for them to consider whether he should be granted further leave to remain on a family permit. So yeah, all very stressful, especially if he misses the boat, because he could be, if he didn't make the application in time, he would be, you know, destitute for many months, not being able to access anything really, and living out of food banks, and many clients do. And just having to understand the immigration rules is scary enough as well. Any other questions, or are people thinking that, you know, they're wanting to go to lunch? If you want, you can always email me, and I'll try and do my best to answer questions there. So do people, if we look at the original kind of aims of the training, do you feel in a better position? Marianne's nodding her head. Okay, Michael's saying brilliant. Lots of thumbs up. Great. I'm always happy to talk through cases. It's really stressful for you as mediators, but trying to understand, I think the first point is their needs, trying to understand where they are on their journey, and then going from there, and then signposting them to an organization that can support them. Okay, so, and as Fatima will say, very important to get a proper qualified interpreter, because, you know, you can really misunderstand things, and language around immigration is really hard. Sorry,
I'd just
Fatima.
like to add that when it comes to immigration, cultural issues also come into, because in other countries, anything to do with immigration is it's just very it's seen as a problem. So when paperwork come from immigration or any legal agencies, people receiving it will have that element of fear anyway. So it's just be mindful of the fact that whereas in this part of the world we are so used to having letters like this, in other countries, letters from the government, they're not welcomed. It's always bad news, and therefore being mindful of that really helps the clients as well.
Yeah, and I think it's a really important thing about the cultural aspect of it, because if somebody's talking about their sexuality, I think, you know, in some cultures they won't feel very comfortable to talk about that. So for example, my Pakistani male who has been in an arranged marriage and then comes to the UK and then identifies as being gay, sitting in a mediation room, he may associate that with authority, and it's about making that space really safe. Absolutely. And people like Fatima will explain that, you know, this is, we always talk about the four sides, you know, the room being totally and utterly confidential. For the British, I always say it's like being going on a holiday to Benidorm as mediation. What happens in Benidorm stays in Benidorm, and it's the same for mediation. So maybe adapting that slightly for your international clients and service users.
No, I just wanted to say thank you very much. It was very enlightening. Thank you, Stuart.
That's okay. Thank you. Right. How do you suggest I go about finding an interpreter in a non-legal aid case? There you go. Fatima, I think you're probably better to answer that than me.
To be honest with you, I've just recently qualified, so I wouldn't have a vast knowledge of agencies that provide it, but it's just a case of looking what is offered locally, really.
Yeah. And Marianne has...
oh, someone has a better idea, sorry.
Marianne, please. Oh, and we have to ask you to unmute.
I can recommend 3 national bodies that provide trained interpreters, some of whom have had training in mediation as well. And if I send the details to you, could you circulate them?
Certainly, that's no problem. That'd be good. Thank you very much. So 7 minutes to go. Shall we call this an early lunch, or are there any questions that are kind of people are burning to ask, have a burning desire to ask? No. Well, thank you very much for coming along as well. It's great that I see so many people taking an interest in helping international clients and service users, because as you can see, they are in a very vulnerable position and need a great deal of support potentially and signposting. So thank you. And what I'll try and do is maybe I can even make this available if I manage to press all the right buttons on our website at some point, so people who didn't manage to come can watch it later. But like I said, get in touch anytime. I'd be very happy to do my best to try and answer your questions. Oh, and somebody said this should be compulsory training. That would be great. Michael, I would really like that. I think there's just so many things that we need to know as mediators to be able to do our job effectively. And for me, it's constant. I think I clocked at this year, I think 55 CPD points from going on courses, because I keep thinking, I need to know about this. I need to know about this. It's just so important that we constantly kind of develop our skills. So and I can see Macarena's here, who's a brilliant trainer as well, who does great training with Ataraxy. Really, maybe we should put it through Ataraxy maybe in the future to see and help more people access it with your kind of database. Okay, so if it's okay, I'm going to finish it now, but I'll hang around if anybody wants to ask any questions. So feel free to have an early lunch, enjoy the rest of the week, and I will be back in the office on Monday. Okay, so thank you again.
Bye. Thank you.
Bye, everybody.
Bye.